Hello, my name is Barbara Beveridge. Welcome to Book 1 of my course in Legal English for International Commercial Transactions. You will see in this book that we're looking at some of the differences between civil law legal systems and common law legal systems. In the book, I've given you an introductory section, and I've also given you two papers that I have written. Now, the first paper came out of an International Bar Association conference held in Barcelona, Spain. My paper formed the introduction to a subsequent issue of the International Business Lawyer magazine entitled Same Words, Different Meanings, English Legalese in Non-English Contracts. The second paper I've given you is from a symposium on legal linguistics held in Rovaniemi, Finland. My paper was first published in a journal entitled The Development of Legal Language, and that was published in Finland. It was subsequently published in Switzerland in a journal entitled Hieronymus. Now, you will find in the book that I'm talking about many differences between the two different systems. In this video, I'm simply going to mention two differences. And the first has to do with the civil law doctrine of culpa in contrahendo. And as a civil law lawyer, you may be surprised to learn that this doctrine does not exist in the common law. In most cases, there is no duty on a common law lawyer to negotiate in good faith. And in England and Canada, the courts have very explicitly said that there is no duty on lawyers to negotiate in good faith. And the language they have used is that this duty is inherently inconsistent with the position of a negotiating party. So you can see it's pretty important for both lawyers, civil law lawyer and a common law lawyer, to be aware of this difference in the systems when they're negotiating the terms of a contract. Another major difference between the two systems has to do with the rewriting of contracts. Many civil law countries have a code provision that authorizes the court to rewrite the contract so that it represents what the parties intended. Now, this is very different from the common law. For us, it is very rare to have a court rewrite a contract for us. So the way we proceed is that it just doesn't happen. So again, a big difference between how a civil law lawyer approaches the drafting of a contract and how a common law lawyer approaches the drafting of a contract. Very different when we know that our courts aren't going to rewrite our contract if we leave something out or if we make a mistake. So I hope you read the articles, these two papers I have given you, along with the introductory section. And I hope that they're of assistance to you in your practice and that you find them to be informative. Thank you.